Thank you for having me here. I'm back. I was with you in 2019, and good to be back here again. Thank you, Raj, and the team at ISACA for inviting me. I think this is a very important topic. Had we not had the no confidence motion being tabled in Parliament, we probably would have had a new law today. But we don't have a new law. But before the end of the monsoon session, let's hope we have a new law so that we start the process of having a consolidated framework for data privacy in India. I heard GDPR being mentioned in the previous presentations, and we don't have a comparable law. We tried to, since 2017, tried to have a law since we recognized privacy as a concept, as a fundamental right within the right of life and liberty. We've been trying to get a law, but every draft had its own issues. And eventually, we'll talk about the bill before the Parliament. The Digital Personal Data Protection Bill has really evolved as a, I would say, how do I move this? Let's see. Has really evolved as a principle-based legislation, which is very interesting. We'll talk about the principles, and I'll explain the concept of the legislative process, because for the audience, a lot of you are interested in the technical aspects of the law, because you're experts, cybersecurity and various other experts here. So we will touch upon those, but before that, I want to explain the concept of how this law got written. So I hope this is working. So the law, the previous version that was debated a lot, including at ISACA, was the Personal Data Protection Bill of 2019. The Personal Data Protection Bill of 2019 really used GDPR as its basis to formulate the law on data protection for India. It evolved, it tried to improve on GDPR, but a lot of the principles were the same. A lot of stakeholders, I'm sure many of you commented, a lot of stakeholders were very unhappy with that legislation. They just found it very onerous. Few concepts, which we'll talk about through this presentation, few concepts made it very difficult to maybe understand, but also implement the law. The implementation challenge came from, I would say, two aspects, two main issues that were there. There were many issues, but the two main issues for many multinationals that you work with. One was data localization, because a lot of data, especially if it got categorized as sensitive or critical, a lot of data may have had to stay in India. And that would have been an administrative challenge, a costing issue, because you would have had to put up servers in India to retain the data in India. And also processing becomes a challenge if data can't move across borders. And the second was there were some definitions of categorization of data or personal data. And one of them was critical personal data. Now, we have today sensitive personal data as a concept, but critical personal data, no one really understood what was it, how can it be critical, and are you talking about criticality vis-a-vis the nation? Are you talking criticality vis-a-vis the person whose data it is? So there were a lot of these questions that came up. Of course, there were possible criminal penalties. There were a lot of things over there that were making people upset. So not just feedback from stakeholders, but also the Joint Parliamentary Committee, when it gave its feedback, the government just decided to scrap that law and come up with a new law, a new bill. And the new bill is the start of a whole plethora of laws that will come in India, ending up with the Digital India Act, which will take care of legislation on this particular issue of data the cyberspace, and many other aspects that we currently may not have adequate legislation on. How do I change the slide? I don't, oh, just, okay, a second. So what are the principles that this legislation is based on? So just to explain how a law is written, a law is typically written as the basic act is the framework which says what the government or the state wants people to do vis-a-vis a particular subject matter. The secondary legislation, the rules, regulations, guidelines, notifications, give the tactical aspects. So the strategy is given in the main law, and the tactical aspects come later. However, the strategy itself has a level of detail in it. This particular bill which has been tabled before the Parliament is very different from anything else you may have ever read because it's principle-based. It hasn't gone into detail. Yes, the details may come with the secondary legislation. However, the basic draft of the law that exists is very unique and very different. Any one of you who's not exposed to laws will also find it a very easy read. It's written in plain and simple English, giving out 7 concepts and just addressing these concepts in the different sections. Nothing else is there. Very simple, very basic. If you were to pick it up, and I tell many people, it's just about 20, 30 pages, not very long. If you picked it up on a short flight to, say, Bangalore to Chennai, you'd finish it and you'd completely understand it. It won't be like, oh, I need a lawyer to read this and explain it to me. It'll be very, very simply written, clearly written bill right now. When it becomes law, it'll be a statute. So the hope, and a lot of you will want to know, what are the details? How is cybersecurity being addressed? How are various issues being addressed over there? How are data breaches being addressed? All of that will come in the secondary legislation. All of that will come by notifications of the central government, of the Data Protection Board that will be set up. So what are these principles that the law has been written on? Some of these, and these are principles that every law, including GDPR, has been written on or are the basis of. And the 2019 bill was also written on the same principles. But if you read the two, they're chalk and cheese. So the first principle is a fair use of the data. So if you are collecting personal information of someone, collect it for a lawful purpose. And the usage has to be fair and transparent. You're taking someone, it's almost like taking someone's property. You are the person who collects the property, different names globally. We've called him a data fiduciary, meaning there's an expectation of trust between the data subject in India will be called the data principal and the data fiduciary. This trust is encapsulated in the fair and transparent use of personal information. Lawful is obviously important, can't be for an unlawful purpose. The concept of purpose limitation. What does purpose limitation mean? You use it for the purpose you collected it. You told someone you're taking their personal data for a purpose A, use it for purpose A. Don't use it for another purpose. If you do want to use it for another purpose, you'd probably have to take another consent, another approval of the owner of that data. That is the data principle. Data minimization. Only take data that you need for the purpose. Don't just collect a huge amount of data or data far more than what you require. Accuracy expectation is there with the data principle. The person who gave you the data expects you to keep the data accurate and up to date. Storage limitation, you can't store data forever. take the data, use the data, and then do not keep the data. You can destroy it, you can return it, whatever you want to do, but do not keep the data with you beyond the purpose. The security expectation is there already today, and I was talking with someone earlier about ISO guidelines. So that's what's been prescribed today. We don't have the new guidelines of what the parameters will be, but there is an expectation of the data principle that you, as a data fiduciary, will keep the data safe, secure. And for that, you will try and do the best that you can industry-wide and prevent a data breach and loss of his or her data. And finally, there is an expectation of accountability on the person who decides the purpose and means of processing data. This is what may be called the data fiduciary. Some highlights. We'll go into several of these later, but the DPDP Bill, even the name, a little bit different from the previous bills, which was Personal or Data Protection Bill. This is talking about, this has added the word digital. So it's digital personal data, which means that the data may have been collected online, or it could be offline data that's been digitized. It's the personal data needs to be digital to fall within this scope. Interestingly, I've given you rights of, or I spoke about some expectations of the data principle. But like our Constitution, the data principle, because he's being given rights, is also being given duties. He can't abuse the rights. Many of our laws are written, and you're all familiar, you read the newspapers, many times our laws are written for a particular purpose, are abused by the person who they are expected to protect. This one requires the data principle to also follow some specific duties. If you cannot meet the guidelines, very important, if you cannot meet the expectations of the bill, remember that the bill provides a way out. If you know you are not being able to meet them, go to the Data Protection Board and tell them that you can't meet those, whatever the requirements are, for whatever purpose. At least you will get some protection from the penalty if you were ever discovered not to have met the requirements. So this is a great provision. It helps companies who are trying but are unable to meet certain requirements to go up front and make a voluntary disclosure. In terms of, this is the next point is a recognition that we speak in English, everything here is written in English, except for one word of one alphabet, Sir, that's been written in Hindi or Devanagari. Everything here has been written in English, but English is not a national language in India. Does anyone, just as a quiz, since you had a quiz earlier, what status does English have in India? Anyone? What is it? No, you will have to give me the correct name for English. English is not an official language in India. What does India recognize English as? It's called link language. Why? Because two states in India, if they speak in two different languages, how do the states of Karnataka and Tamil Nadu speak to each other? If all the documents from Karnataka were written in Kannada and went to Tamil Nadu, and all the documents from Tamil Nadu came to Karnataka written in Tamil, how would each party read them? The only way they can read them is if there is an English translation of each document which goes from one state that doesn't speak the language to another state. Therefore, it is a link language. So English is not an official language, but we have 22 official languages in India. And the data principle has a right to ask for everything that I'm going to talk about, notice, privacy policies, everything. In theory, he can ask for that in any of the Indian languages. So that's a great recognition of the languages that India has. You will get a little disturbed by the 500 crore penalty possibility that exists in the bill. But when I come to the penalties slide, you will realize it's not something that will be imposed without due process or without following the principles of natural justice. Some key definitions, I've used these terms, but I just want to reiterate them. The data principle is the data subject. If the data subject is a child, then you have the parents or the guardians also included in the definition. Personal data is the only definition that has been provided. No sensitive personal data, no critical personal data. On that same token, non-personal data has also not been defined, and other data sets have also not been defined. So this is only focused on personal data, which identifies an individual. So you can identify that with an individual. Data fiduciary is the person who decides to take the data and what he's going to do with the data. That's otherwise known as the data collector. There's also a data processor. What does the data processor do? Any of these activities, including, theoretically, collection, recording, organizing, storage, destruction, any of these activities fall within processing. So if you're doing any of these activities, you could be a data fiduciary, but you could also be a data processor, which could be the same person or different people. Public interest I'll use many times. It has a very simple, and many of you are aware, concept. The sovereignty of India, the integrity of India, security of state, friendly nations, friendly relations with other nations, public order, preventing offenses, and, which is very interesting, false information, false news, fake news has also been covered, that you shouldn't be spreading that. There is going to be an authority. The authority in different countries is called the Data Protection Authority, DPA or DPO, depending on the country. But here it's going to be called the DPB, the Data Protection Board. This board will do all these activities: enforce compliance, impose penalties, issue directives, conduct inquiries, and all of us will have to follow their directions. Now, some concepts in more detail. Privacy notice. When you are going to collect personal data, you need to inform the data principal about the fact that you're collecting and give some information. What are you going to do with it? How long will you keep it? What is the purpose? Are there going to be many people who are going to look at the data? Are you going to send it overseas, send it to different people? Are you the processor? Is somebody else the processor? Well, as much information as you can give. And if you've already collected the data, which is very important, and the bill comes into force, say, next week, as soon as the no confidence motion has been dealt with, then remember, you have to go back to the people whose data you collected and make sure you gave them the notice that's required under the bill. So all of you should start getting ready. I have a roadmap right at the end, but all of you should start getting ready to prepare your templates for the privacy notice that you need to give, even if you have already collected the data. There is a concept of a significant data fiduciary. Just remember, right now we don't know who they will be, but once you are deemed to be a significant data fiduciary, your compliance level goes up. So my last roadmap slide will have two flags, one for data fiduciaries and one for significant data fiduciaries. So for them, you have to have an independent data audit. You have to have a data protection officer. you have to do an impact assessment. So there's a lot more compliance that is required for a significant data fiduciary. And how do you determine a person is a significant data fiduciary? By bullet number 2, it is a class of people who may be dealing with data which could cause harm, which is so sensitive, which is relevant to the nation. So all of those, any of these criteria may make the government believe that A is a significant data fiduciary, more compliance needs to be put on them. Now, rights of the data principal, I've already spoken about, but some rights, don't have to read each one, but grievance redressal, if you have a problem, it needs to be redressed within a short period of time. Access rights, you do have rights. You can access your data anytime, correct it, do whatever you want with the data. Information right as regards what's happening with your data. Nomination rights, very new concept in under Indian law, where you can nominate, like you have, it's almost like giving data the right of property. Like you have property and you say, after my death, my land will go to my son, you can nominate someone to handle your data when you either are no more, but when you cannot handle it, you may be incapacitated or whatever may happen. But two concepts don't exist. Data portability, so which means that the data that you've given can only stay as it was given. It may not be portable to another data silo, and you may not be able to move it from one platform to the other easily, which is good for the person, the data fiduciary, because he doesn't have to put in more processes to convert the data in another format. And the right to be forgotten. The erasure is there, you can erase your data, but the right to be forgotten, which is really that you leave the data with the data fiduciary, you're not erasing it, but you're telling him, don't share my data with anyone. Let no one know that, no one have access to my data. That's not there. Then the duties I mentioned, you just have to, the duties basically say that you have to act in good faith. You can't fool people, you can't take advantage, and you must give authentic information. Now, breach notification is a new concept that globally exists but does not exist in India. We don't have a concept under current law of breach notification. So if you have a data breach, you're not really required to notify anyone for the data breach. For a cybersecurity incident, of course, you do need to go to CERT-in. Now, here the concept really is that if personal data of someone has been breached and is available in the public domain, you need to inform that person. Of course, you need to also inform the board. But it is important to inform the data principal. This is a concept that exists globally but wasn't there in India. No time frame has been prescribed right now, unlike CERT-in, which has a 6-hour timeline for informing them of a cybersecurity incident. The impact assessment that I spoke about for a significant data fiduciary, this is really a concept where you, the significant data fiduciary, needs to assess all these aspects. What can happen with the data? Why is it collecting data? How long will it store it? How long will it manage it? What harm can happen if it gets lost? How is it managing it? So the whole impact assessment needs to be done and be ready for inspection. Penalties that I spoke about are these. Of course, there is everyone looks at the 500 crore penalty in each instance and says, my God, the penalty is so high. But remember, that penalty has to go through all these parameters before it is going to be imposed. What is the gravity of the offense? Was the offense repeated many times? What is the impact of levying that penalty? Will there be a change in the behavior? Will the industry change its behavior. What kind of personal data was affected? So all of these, and of course, whether the person acted for their own benefit, and because of that, the loss happened. So all of these things will be looked at. I like the fact that there will be a proportionality, that it's not that 500 crores will be imposed in every situation. There has to be a proportionality of what happened and the penalty. So I do believe it's not going to be 500 crores in all instances. It's up to 500 crores. The other thing to remember is that you as a data principal do not have any rights against the data fiduciary for a penalty. Only the board can levy the penalties. Of course, you can complain to the board and then the board will levy. So you can't raise a complaint yourself against the data fiduciary. So in that sense, the structure has been very well put in place so that no one is getting overburdened. Cross-border data flow is easier. We don't have the localization requirement.
How the compensation will be the affected principal is unable to get the only data protection board is going to raise the penalty. Who will be the beneficiary of that penalty amount being collected?
So in most countries, it's the board itself. It's the government who takes the money. So it doesn't go to the individual who suffered. It may go to the individual who suffered, but the money goes to the government, goes to the treasury. So it is not necessary. The assumption shouldn't be that the money will be distributed amongst all the data principals who were affected. Maybe. There may be data principals who suffered a loss and may get something. But the money that you pay as a penalty goes to the government. Yeah.
Will the data principal be precluded from going to court to assert his rights?
So because there is a remedy available under this law, no court will unfortunately accept. It doesn't prevent the data subject from going to a court, but if he went to the court for something that's covered here, the court is going to throw it out.
So it will be only DPB?
Only DPB. For items related here, there may be something else that he goes to the court for, which may be a larger
only
issue.
for this?
For this,
that
no.
Means by this act, the data principal's rights have little been curtailed.
Data principals' rights have not, how?
Because they cannot go use, my data is done something, I have serious damage I have suffered. I complain to data protection board. Data protection board will conduct an investigation and find out, and it will levy penalty and it will go to the government account.
Yeah, so it may give it to you. So there's nothing that prevents the data protection board from giving you compensation. That it doesn't say.
No, if data protection board unilaterally decides that you cannot be given, it is they have done a infringement, we will collect penalty. Can we go against data protection board?
Well, I would say we'll have to wait for that to happen, but I don't believe the board will be, there will be rationality, I would believe. And
what, it will be a quasi-judiciary body?
Yes, it will be. And the other thing is that oftentimes, my personal view is that the penalties will be very small. They won't be 500 crores. And therefore, yeah, so it's just, they've just picked up from other jurisdictions, GDPR is so. And oftentimes, we don't have a concept of class action suits in India. We have some concept under company law, but we don't really have that concept as it exists globally. And for that reason, we don't have the concept of distributing the money amongst many stakeholders. So the money is not going to be large. The people claiming may be large. You'll end up getting 1,000 rupees, or you may end up getting a very small amount of that money.
Sir, I have a question.
We'll take the questions later. He's yet to finish his presentation.
Sure.
So we'll quickly get to that. Yeah, please go ahead.
So cross-border data transfer has been made easier. The government will come up with a list of countries where you cannot, or maybe countries that you can, but I believe it will be you cannot send data to. I think it'll be probably all countries other than some countries where we may not have good diplomatic relations, or we find that the data protection laws of those countries are inadequate. So that is very good, and the lack of data localization is a welcome step. Personal data of children will be an issue because the government is very concerned about children's data, and the parents need to be involved in terms of consent to use children's data. Now, the impact of this, and I put this up because there probably are a few edtech and gaming companies here who are targeted on children. You may have to re-look at your strategy when the bill comes about. Consent and deemed consent, you understand what consent is, consent to use your data. Somebody is taking your data, and you give consent for that person to use it for a particular purpose. Deemed consent is when the government or the bill, or whichever way, or a circumstance deems that you have given consent. Whether you gave it or no is irrelevant. It could be a thing like a medical emergency, an epidemic, an earthquake. It could be a riot. It could be many things that happen where going to each individual and getting consent is physically not possible. In addition to that, the government has also put up some more conditions like contractual obligations. You contracted for something where, as a part, you may not have said, I also give consent for personal data. But as a part of that contract, to fulfill that contract, personal data has to move from one to the other. So those situations, an employer-employee situation, when you become an employee of an organization, the employer has to use your personal data. It's any data that identifies you. Otherwise, it's a challenge. How will the employment relationship move forward? So those things have been allowed. M&A activity has been allowed. So, and the government has the ability to come up with fair and reasonable reasons in addition to these where consent may be deemed to have been given for use of personal data. Now, we will come to a point where you will be all getting so many messages for consent, and you'll all just keep clicking given, yes, 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 yes. So the government said people are not reading what they are giving their consent for. So they've come up with the concept of a consent manager. You tell the consent manager that anything that comes to me, it'll be routed through that platform, it'll be a platform. Anything that comes to me which takes care of A, B, C, D, just give consent. But I'm particular. I don't want to give consent to these type of usage of my data. So the consent manager will use that direction, and you will be able to manage your consent much better. So I think this law is allowing or is encouraging all of you to digitize. Digitize everything that you're doing in hard copy, you're doing anything other than digital. It wants people to move to digital. So anything that you have today, which may be in a hard copy format, many employers have big files on every employee. They're saying digitize them. That's one of the encouraging factors that the government is encouraging people. There's no concept of privacy by design. Many of you are experts in privacy by design. That doesn't exist in the law. And as I said, many of these other things have been, I've already covered, but just highlighting them here. But one interesting thing to remember will be that at the end, when the act, if the act comes about, when it comes into force, the government of India or the state governments will end up becoming the largest data fiduciaries in India because they process so much of personal data of each one of us and so many other people, that they will end up becoming that mammoth, significant, or much more than significant data fiduciary. And that is the body that also is determining how consent is to be given, deemed consent, and various other aspects. So that's an interesting thing to take away from today. This is just a roadmap of compliance for people just to get ready, because the law is coming. So what all do you need to do? Some of you who may feel you are in a sensitive area where you're dealing with sensitive types of data may need to appoint a data protection officer, at least get a draft of a privacy notice in place, get your privacy policies in place, and then those who may end up being significant data fiduciaries may need to do some other issues like impact assessment and having a notification process also in place. But the others can try and think of how you will address grievances that come about of data principles and start thinking on these lines. So this is where I guess we are headed, and but we'll have to wait for the no confidence motion to end that debate to end, and then probably this law and a few others may see the light of day. So with that, thank you very much. I am available on this email ID and phone number. Thank you.